In my opening statement, I made the thing that the Democrat state employees were preparing forms for people in divorce forms and family court forms that do not comply with the state constitution and in fact violate it. Juarez, a referral from one court to another for the purpose of entry in order should be specific and unambiguous. Now, what happens is, the judgment of divorce states, this court retains jurisdiction of this matter concurrently with the family court for the purpose of specifically enforcing such of a provision of said agreement. That's not specific referral. It's just saying is it a referral? Isn't it? At issue is whether the Supreme Court sentence stating that family court shall have concurrent jurisdiction with the Supreme Court relating to matters of support contains a referral to the family court for purposes of entry of an order of support. This court holds that it does not. My argument, exactly. This is in all the judgments of divorce. It's not a referral. Either the Supreme Court's going to retain jurisdiction or they're going to refer it. Or it's going to be silent, which means they haven't referred it. It's got to be specific. Even Section 251 states what has to be specific in order to refer it. It has to be filed with the clerk. Now, family court order to modify that you file with the family, they have you filing with the family court. It says under the terms of, and then you get to pick, judgment, Supreme Court, other court order, has not retained exclusive jurisdiction to modify. The Constitution doesn't require the Supreme Court to retain jurisdiction. It requires the Supreme Court to refer it. So in other words, this should read, under the terms of the Supreme Court order, has referred the matter to the family court. This is completely wrong and in violation of the state constitution. And they hand this out in all their booklets, and it's on their Unified Court System website. This is a Supreme Court judgment. And they only do it with settlement agreements. They don't do it with support, if the court determines support or anything, only with settlement agreements. Which, as we've already documented, family court can't enforce or modify a separation agreement. So, but they have it in here anyway. This court retains jurisdiction of this matter concurrently with the family court for specifically enforcing such provisions of said agreement. They don't have a jurisdiction to hear agreements. So how can it be concurrently retained? It can't be. And that is not a referral. There is no mention of this concerning Supreme Court judgments where there is no agreement. But there's no referral in here stating that it's referred to the family court.